state of Florida. Please proceed.
May it please the Court. I am Stacy Biggert with CCRC North, and we represent Johnny Calhoun in his post-conviction case. I would like to reserve 5 minutes of my time for rebuttal, please. And in the remaining amount of time that I have to talk to you, I want to talk about Mr. Calhoun's ineffective assistance of counsel claim, which is claim 4 of his initial brief. Your Honors, this is a case of an overwhelmed capital defense attorney who is trying a difficult capital murder trial essentially by herself. She has a second chair, but her second chair is not qualified to handle capital cases, is a misdemeanor attorney, and describes himself, not me, as a bag holder. This is also a case where the defense counsel had an investigator who seemed disinterested or unmotivated in investigating this case and made such statements at the evidentiary hearing as, I don't have the time or the energy to chase down those leads. So as a result of this defense attorney essentially trying this case by herself, she failed to conduct an adequate pretrial investigation of this case, including investigating her alternate suspect. She failed to challenge the state's forensic evidence. She failed to challenge the state's identification witnesses. She failed to object to harmful hearsay that allowed the state to argue consciousness of guilt in their closing argument. And she also elicited harmful evidence in her case in chief through not one but 2 witnesses. And then she allowed the state to misstate the evidence in closing argument, which amounted to an argument that Mr. Calhoun gave a confession that he did not give. The cumulative effect of all of her errors prejudices Mr. Calhoun, because but for those errors, the result of his trial probably would have been different. Trial counsel had a duty to conduct a reasonable investigation. And this court has said in Fitzpatrick v. State that pretrial preparation, principally because it provides a basis upon which most of the defense must rest, is perhaps the most critical stage of the lawyer's preparation.
Let me just ask a quick point. Where in your brief did you raise the cumulative error point and make that analysis?
The initial brief was not drafted by myself. I think, though, that under Strickland, you have to look at all of the errors.
Well, even if you waive the issue by not raising it?
I don't know that the issue is waived in the briefs.
Okay. Maybe when you get back up, you can show me that you raised.
Yes, sir. On rebuttal, I will look. Thank you, sir. But in this case, we don't have strategy reasons for counsel's errors. Trial counsel's strategy that she stated was she planned to attack the state's case, which is reasonable doubt, and then she was going to imply Doug Mixon's involvement. Trial counsel did some investigation in this case, but she only did enough investigation to know that more investigation was needed. Running into hearsay is not a reason to stop investigating. Running into hearsay means that you need to investigate further. Hearsay and running into difficult witnesses.
What is the particular hearsay statement you're talking about now?
Counsel testified at the evidentiary hearing, as well as her investigator, that when they tried to investigate the case, they would just run into hearsay statements, and so they couldn't develop anything.
You're not talking about the...
No, sir. I'm not talking about what happened at trial. I'm talking about the pretrial investigation. Right. Okay. Running into hearsay is frustrating, but you don't stop investigating your capital murder case because you're frustrated. And in this case, she had a lead in her case that was not hearsay. It was actually a lead that was given to her whenever she deposed her alternative suspect. And he gave an alibi witness and said where he was on the night the victim went missing in this case. Trial counsel never talked to this witness. Trial counsel never deposed this witness. She never did any investigation of this witness. And whenever her investigator testified at the evidentiary hearing, his testimony was further evidence of how disjointed this defense team was. This is essentially a two-person defense team because I think that you can't count the second chair as making any contribution.
What did that purported alibi witness testify to at the evidentiary hearing?
At the evidentiary hearing, he testified that Mr. Mixon was not with him. So, essentially,
Didn't the trial court, though, find that testimony to be false?
I think this court needs to have...
Did you answer my question first? Didn't
Yes,
the
sir.
Okay.
Yes, sir, he did.
Is there competent substantial evidence supporting that credibility finding?
No, sir.
There's not, didn't Mr. Contreras say that he specifically talked to an officer from one of the police departments, and that officer from the police department, I think Officer Morgan was his name, testified at the hearing, and Officer Morgan testified that what he said never happened? Wasn't that one significant inconsistency?
Yes, that did happen.
Isn't that a competent substantial basis for which to find testimony to be false?
It could be. The problem that you have here with this judge's
Assuming
order...
that there is competent substantial evidence for the trial court's determination that it's false, and we're not going to reweigh that, there's no prejudice with respect to this claim, correct?
Well, it's evidence of... It's further evidence of their failure
you would
to...
agree that would mean there's no evidence with respect to that claim?
If this
it's not believable.
court accepted the trial court's finding.
Right.
But I'm asking this court to
Okay,
give...
is there any legal basis for not accepting a credibility finding by a trial court under these circumstances?
Yes, sir, because I think that you have to look at this order in its entirety, and there are... I think this
No, I'm
court...
talking about specifically the credibility finding with respect to this particular witness. What law would allow us as an appellate judge who were not in the courtroom to say that that credibility determination is invalid, particularly in light of the evidence that we just discussed?
In the judge's order, there are portions of his discussion and his analysis of this witness that come straight from the state's closing argument. And part of the concern that I think this court should have with this order is that, and I understand that a court can draft an order, and we have several trial judges on this bench, can draft an order however you want to draft the order. If you read my closing argument and you read the state's closing argument and you have analyzed the evidence and you've reviewed the transcripts and you have made a finding that is consistent with what that one party may say, you may pluck that paragraph out and put it in your order, because why should you reinvent the wheel? The concern you should have with this order is this order misstates, it's factually inaccurate in many places, it misstates the law in many places, and this is a product of copying and pasting the state's closing argument into the order. For example, the incorrect Strickland standard is stated. So in the Strickland standard in the beginning of this order, the Strickland legal analysis, it is 100% from the state's closing argument. And in that, the judge misstates the Strickland standard. He says that the defendant probably would have been found not guilty or gotten a life sentence. That's not Strickland. And so either the court is inattentive and he's not paying attention to what he's putting in his order because he's just taking it directly from the state's brief, or the court doesn't understand the law. And either one of those is not something that this court should be concerned about. There's another instance, and it goes to one of our ineffective assistance of counsel claims. It is the claim where counsel recalled Glenda Brooks to testify that whenever Mr. Calhoun was at her house...
I'm hearing everything you're saying. I'm having a hard time following the logic of whatever you're saying gives us a legal basis for overruling the credibility determination of the trial judge on this particular witness, the fact that he got the Strickland standard wrong and took it from the state's brief. I'm having a disconnect with how that reflects to the issue.
Because that's not the only error in this brief. That's not the only factual misstatement or misstatement of the law. And so in the portion about Mr. Contreras, the discussion about Mr. Contreras is Officer Morgan, and it's also this discussion that comes directly from the state's brief that doesn't really make a lot of sense, that he asked for an interpreter at the hearing, and he actually does speak English, and so therefore he's not being honest. But that's not true. He testified at the hearing that he does speak English. He does speak broken English, that when he spoke to my predecessor when she interviewed him prior to the evidentiary hearing, he could understand her, but for the purposes of this hearing, he wanted an interpreter. So there's this analysis of him that is, again, cut and pasted from the state's order, that he must be dishonest because he actually does speak English, and that's not true. And then in the issue with Glenda Brooks, this is very important because this was further harmful evidence that was elicited in the defense's case in chief. The analysis of why she was called is, again, cut and pasted from the state's order, and it's factually wrong. So in this situation, defense counsel called Glenda Brooks, and she testified, she asked her, whenever you got the phone call that Mr. Calhoun was on a flyer, a missing persons flyer, were you then uncomfortable with having him in your home? And then the questions continued. Did you ask him to leave? And then there are a few more questions, and then she says, and you have a granddaughter, don't you? And she says, yes. So our argument is that she elicited harmful information in her case in chief that Mr. Calhoun was dangerous and on a missing persons flyer, and therefore he needed to leave her house. Defense counsel didn't recall why she did this in her closing, in the evidentiary hearing, but then she said, oh, yeah, I think it was because she had too many people in her house.
Didn't the state first put on evidence about the missing persons flyer? That was already in front of the jury.
That's not the problem in this case, Your Honor. The problem is that she elicited information that he was dangerous, and then the court copied from the state's brief this idea that the reason why she actually did have a strategy, not that she stated, they created a strategy for her, that she called her to show her inconsistent statements about the flyer and what Mr. Calhoun said when he heard about it. But that's not true. That is factually inaccurate. That's not what happened in the defense case in chief. What happened in the defense case in chief was she was impeached about her prior inconsistent statements about what Mr. Calhoun said about the victim, whether or not he said, I don't know her, or that was the person that was supposed to pick me up. So the court, by copying exactly what the state wrote in their brief, created a strategy reason that's factually wrong. Because that's not what happened in the defense case in chief. In the defense case in chief, again, because this lawyer was overwhelmed, she did try a 7-day guilt phase by herself, a week and a half, with no help. She did not have a cogent strategy. They hadn't thoroughly investigated this case, and so she puts on a witness and just kind of forgets why she did it. And so she never cleared that up with the jury of why she put this witness up to talk about how she wanted Mr. Calhoun to leave. And so it is problematic whenever the court, and this court should be concerned, that whenever a court just copy and paste from another brief, another closing argument, that if it's factually wrong, completely factually wrong, it's not showing that they're doing any type of real analysis. And that's concerning in this case. That's not what happened in those two phases. It's completely wrong. The other issue that was brought in her case in chief was she recalled the investigator in this case. And she recalled the investigator in this case to testify about some items that were consistent with the victim's car that were found on property belonging to Mr. Calhoun's family. It was a tag bracket from a car that was consistent with the victim's car because it was from the same dealership. And there was also a piece of cardboard that had an oil stain on it that they'd found in their investigation that the victim's car had an oil stain. It was not brought in the state's case in chief because Investigator Raley said that he couldn't say that was definitely her tag. I assume this dealership sold a lot of cars in South Alabama and North Florida. And he couldn't say for sure there was this oil stain, so it wasn't brought in. So she called him to testify about those things. Now, what she says that she called him for was to show that it all just looked a little too made up and everything is falling on Mr. Calhoun's property. She never argued this to the jury. Instead, she added more evidence for the state. So then what the state did with this evidence was they bolstered their officer's credibility that he, of course, wouldn't bring in evidence against a defendant if he didn't have good proof of it. And then in closing argument, the state used that evidence to say, well, we didn't bring it in because we couldn't prove it, but it's absolutely consistent with Mr. Calhoun having done this. So it's, again, not doing a thorough investigation, not having a plan for your defense, and then scattershotting your defense and putting in very harmful evidence that hurts your client. She also failed to challenge the state's forensic evidence. And what she said was, in a letter to Mr. Calhoun, I think it's Exhibit 6 to the 3851 motion, but in a letter to him, she made it very clear that in a reasonable doubt defense, what you do is you attack the state's case, and you do it through effective cross-examination of the state's witnesses. So she had a difficult case, and she was going to prove her case by challenging the state's evidence. That means adversarial testing of their identification witnesses, their investigators, their forensic evidence. She was going to test all of this evidence, and she failed to do that as well. So she failed to ask the DNA expert, isn't it true that they DNA tested her alternative suspect? She failed to ask him, isn't it true that he couldn't be excluded as a contributor? So she failed to adversarial test the state's case. And I have 5 minutes left for rebuttal, if I may reserve.
May it please the court, my name is Lisa Hopkins and I represent the state in this matter. I'd like to start with the argument that Ms. Jewell, trial counsel, did not do an adequate investigation pre-trial. In this case, she had her investigator, Mr. Jordan, who also testified at the evidentiary hearing, that they followed as many leads as they could. She even described having doors slammed in her face in terms of trying to find connections to put Doug Mixon as the alternative suspect. She testified at the evidentiary hearing that her strategy was to poke holes to cause reasonable doubt in the state's case, maintain the credibility with the jury, and also try to put Doug Mixon as the alternative suspect. At trial, she had Mr. Mixon subpoenaed to trial. He was there that day, but with the defendant telling her, do not call him, I don't want him called as a witness, along with her observations that he appeared to be under the influence of some type of drug, she made the ultimate decision not to call him during her case in chief. Mr. Mixon did testify at the evidentiary hearing. He testified that Mr. Contreras, while he was at his house, Mr. Contreras was not there. The judge was able to hear Mr. Mixon's testimony, the testimony of Mr. Contreras, Officer Morgan, Sheriff Ward, and Natasha Simmons, and Robert Vermillion, and was able to make credibility determinations based on their statements. He found Ms. Simmons to be completely inconsistent. He found Mr. Contreras to be inconsistent as well. Mr. Contreras testified that he only knew Mr. Mixon through work, that they never spent any time outside of work together, and so it's wholly incredible that Mr. Mixon would go to someone he barely knows and confess to a murder. Mr. Mixon testified that he was adamant. I have never confessed to this crime. I believe that the defendant is the one that's going around telling people that I was involved. Now, as far as the forensic evidence, Ms. Jewell, trial counsel, testified that she was able to consult with Mr. Walter Smith and Mr. White, both in her office. They were experienced attorneys. After consulting with them about the experts, they made the decision not to call an expert for the digital forensic evidence, as well as the scratches that covered the defendant. Ms. Jewell testified at the evidentiary hearing she still would not have called an expert on those scratches because, and the court should be aware that the state did not even call an expert about the scratches. It was made in inferences based on the photos that were submitted to the jury. The jury was able to hear the argument. The state thought it was caused by fingernails. The defense argued it was caused by running through the woods, that the defendant was admittedly in, as evidenced by him showing up at the Brooks' home about 1.5 miles from the site of where the car was ultimately found. Now, as far as calling Ms. Brooks during her case in chief, Ms. Jewell did testify that initially she was she could not remember why she had called Miss Brooks, and then after refreshing her memory, she was able to say, I believe it was based on a conversation I had with the defendant. I was trying to get out that it wasn't that she didn't want the defendant in the house, it was that she didn't want anybody in the house based on the flyer. And sometimes that when you put a witness on the stand, you can't always get them to say what you want them to say, and she did admit that Ms. Brooks was a very difficult witness for her. As far as Investigator Rayleigh, she testified that she commonly puts on the law enforcement witnesses during her case in chief to point out that they were not forthcoming to the jury. She tried to bring out that there was an unknown shoe print that was recovered that could have shown a possible alternative suspect that the investigation did not go into. And again, her ultimate strategy was to point out the inconsistencies, play off the identification evidence, but the evidence that was presented at the evidentiary hearing does not negate the DNA evidence that was found in the defendant's trailer, 1 in 38 quadrillion. That is the DNA of the victim, her blood on the duct tape and on the white quilt that was recovered from the trailer. 1 in 27 quadrillion, the DNA of the defendant found in that trailer. Now, also, Mr. Mixon's daughter, Brittany Mixon, who was a witness in the case, Ms. Jewell testified it was an implication that she was involved in this case, and that because her DNA was found in that trailer, it was implied that Mr. Mixon's was also found because it was only 1 in 800. So it was a very low amount that they could not definitively connect Mr. Mixon to the forensic evidence that was recovered.
Let me ask you about a fairly minor point in one of the claims. The claim regarding what Petitioner terms classic hearsay, the failure to object to classic hearsay when Tiffany Brooks testified that her boyfriend on the phone, Stephen Bledsoe, told her about the flyer. And the claim is that that allowed for the failure to object to that testimony. I saw a flyer, both of these people are missing, allowed the consciousness of guilt testimony that Brooks gave about Calhoun, saying that he did not know the victim. So that's the claim. And my sort of minor point is you seem to accept that that is hearsay, and I'm having a hard time understanding why that statement by Bledsoe that I saw a flyer with these two people on it was offered to prove the truth of the matter asserted. An issue in the case was not whether he saw a flyer or not. It would seem to me that that would be offered to show context of the relevant and admissible conversation between the witness and the defendant. So why is that hearsay, I guess, is my question. I mean, the claim is she failed to object to classic hearsay, and I don't see that as hearsay. What am I missing?
I don't think you're missing anything, Your Honor. I believe that the evidence of the flyer had already come in through other witnesses, that they testified that both the defendant and Ms. Brown were both on that missing person's flyer. This would be more of an effect on the listener rather than a true hearsay, because once they heard about the flyer, that caused their actions to ask him about it, and then they ultimately dropped him off on a road on the way back to Florida and had him leave the house. It's more of an effect on the listener rather than it is truth of the matter asserted that this flyer actually existed.
And the effect of the listener would be relevant because that explains why she asked the question of the defendant, and without that context, it wouldn't make any sense.
Correct.
Okay.
Counsel, do you have a position on the waiver question that Justice Lawson asked opposing counsel at the beginning of her argument?
I would argue that it was waived on appeal. It was raised in the initial post-conviction motion, but it was not raised as a claim in the initial brief. And as far as cumulative error, I don't believe the court specifically did also find that because there was no errors in the individual claims, there was no cumulative error. So that claim, even on appeal, would be meritless. So If there are no further questions, the state is asking that you affirm the post-conviction court's order and also deny the petition for habeas. Thank you.
The first thing that I'd like to address very quickly in rebuttal is counsel discussed the credibility of Doug Mixon finding that the judge found, which is also another reason why this court should be suspect of this order. So the credibility of Doug Mixon at the evidentiary hearing is also another paragraph. It's on the last page of the order that's cut and pasted from the state's order. And the only person, and the only thing that really anyone agrees in this case, defense attorneys, state attorneys, lay witnesses, people involved in this case, is that Doug Mixon is a liar, a pathological liar. It's woven throughout all the testimony at the evidentiary hearing. Yet the one person that everyone can come to the circuit court and tell you is a liar is another person that he finds credible. And that, again, is a credibility finding that's taken straight, like verbatim, from the state's closing argument.
Wasn't that too supported by competent substantial evidence, though?
That Doug Mixon was telling the truth?
Yes.
I don't understand, sir.
Doug Mixon testified.
He did testify.
The trial court saw him testify.
He did?
And the trial court, and Doug Mixon testified, I was not involved in and did not murder the victim in this case, correct?
That is correct.
Isn't that a basis of competent substantial evidence for a credibility finding in favor of Doug Mixon?
That can be a basis, but also all the other people who testified that he's a liar, including people that the judge found credible as well,
We don't
he's a
have
liar.
any law that says that because somebody's a liar, and they're known to be a liar, that with respect to specific testimony, that a judge cannot credit that testimony as truthful. Do we? Do you know of cases where we've said, oh, well, we think, well, the judge credited that testimony, heard him testify, but because we know that person's a liar for other things, we're not going to uphold that determination of the trial court on the credibility of the witness?
No, sir, I don't know.
So you want us to chart a new path on this?
No, sir, I want you to be concerned about the order and the findings that the court made because they don't necessarily show that he did any independent consideration. That's what I would like for you to do. Because I do think when he misstates facts, and I do think that whenever he misstates law, that is concerning because that to me shows that he has not seriously given consideration to what he is putting in his order. And I think that's concerning, and I think that's concerning throughout all of his findings in this case. Also, I don't agree that trial counsel said that she wanted, that Ms. Brooks said, and this is dealing with the defense case in chief issue with Ms. Brooks. I don't agree that she just wanted, because of the flyer, she just didn't want anybody in her house. That's not the case. What she was asked was, when you learned about the flyer, were you uncomfortable with having Mr. Calhoun in your house? The answer was yes. It wasn't, I was kicking everybody out. It was, I wanted this one person out.
But trial counsel testified that that was the basis for why she recalled Ms. Brooks, right?
If that is the basis for why she did it, then she had a strategy that she did not execute. And so, you cannot have reasonable strategy is based on reasonable investigation and reasonable choice. So she may have had a stated strategy, but she didn't follow her strategy, which is as good as not having a strategy at all.
But she asked about the flyer and about the granddaughter being home, right?
Right. So that makes it sound like I have a granddaughter in my house. This person's on a missing persons flyer. I want him out.
Or that she didn't want anyone else in her house, right?
I don't think that's a reasonable interpretation of that evidence, and I don't think the jury took it that way. And she certainly didn't argue it that way in her closing argument. In her closing, she didn't address it. So I think that there's a spin you can put on that, but I don't think, but what she asked, I mean, the record is clear. Were you uncomfortable with having him there? Yes. Did you ask him to leave? Yes. Do you have a granddaughter in your house? Yes. So the reasonable inference of that line of questioning is, this person's on a missing persons flyer. You're not comfortable with having this person in your home. You have a granddaughter in your home, therefore you want him to leave. That's the reasonable inference from the jury. That is why that is harmful evidence elicited in her case. So she may have had a strategy, But it wasn't a well-thought-out, well-investigated strategy, and it certainly wasn't a well-executed strategy. And I am out of time. I ask you to please reverse the circuit's court's order and grant Mr. Calhoun a new guilt phase of his trial. Thank you very much.
All right. Well, we thank you both for your arguments, and court will now be adjourned. Thank you.